So, a very good evening to all of you. I'm Yashna Soni, your host for today's webinar. I welcome you all to this session scheduled today. I welcome our guest speaker, Mr. Anurag Katarki. Thank you so much, sir, for accepting our invitation and joining us today for enlightening the budding lawyers and young minds connected with us here. Mr. Anurag Katarki is a barrister called to the bar by the Honorable Society of Gray's Inn. He did his undergraduate degree in law from the University of Warwick, United Kingdom. Currently, he works as an associate at AZB and Partners. He practices in a diverse field of litigation ranging from white-collar crimes to commercial arbitration and company law disputes. Once again, I welcome you, sir. I request all our participants to keep their video and mic off throughout the webinar. You can put up your questions and queries in the chat box, which will be answered at the end of the session by our guest speaker. You may raise your hand in the question and answer session. We will unmute you thereafter, and you may ask your query directly from sir. So now, without wasting much time, let's start the webinar. Over to you, sir.
Hello everyone. Thank you, Ashna, for that humble introduction. Good evening, ladies and gentlemen. I'm Anurag Katarki. I have been called upon by Vidhi Parivartan to deliver a webinar on the concept of seat of arbitration. During the course of this webinar, I would be touching upon the meaning of the word seat, its importance, and the landmark Supreme Court judgments over the past decade, which have sought to clarify, or rather, I would say, mystify the concept of seat. Now, let's move on. What is meant by the seat of the arbitration? The seat of arbitration means the juridical seat of the arbitration. Being the juridical seat means it is about the system of law that governs the arbitration. The seat of an arbitration is the country whose duty it is to administer, control, or decide what control there should be over an arbitration. If India, for example, if India is the seat of an arbitration, the Arbitration and Conciliation Act 1996 and the Indian law provide the framework for the procedural steps to be followed in the arbitration. The level of judicial intervention prescribed by the Arbitration Act applies. And for all this, India does not have to be the place where the hearings are held. Now, this, ladies and gentlemen, is a topic which is a host for innumerable litigation. It is very important not to confuse the legal seat with the place for holding hearings, that is the venue. The difference between seat and venue is something where the lines are blurred. Unfortunately, the Arbitration Act also does not explicitly make this distinction. In section 20 of the Act, it uses the words, or the phrase, I would say, place of arbitration interchangeably for both seat and the venue. Now, judicial precedents have sought to try to clear it, and with the help of the Law Commission's report and a 2017 judgment of this called the Indus Mobile Distribution, that the provisions in this mobile distribution case, where it sought to clear the provisions of section 20 were properly analyzed in light of the Law Commission, the 246th Law Commission, where the amendments to the titled the Amendments to the Arbitration and Conciliation Act 1996, which sections 20, subsection 1, subsection 2, and section 21 and 2, where the phrase place of arbitration refers to seat, and section 20, subsection 3, where the phrase place of arbitration refers to venue. Now, common law does not recognize the concept of a delocalized arbitration, let alone one floating in the, a transnational firmament. Every arbitration has to have a seat, or a locus arbitri, which subjects its procedural rules to the municipal law that is there in force. The concept of concurrent jurisdiction, which is available for cases under the Civil Procedure Code, does not fit well with arbitration. And this is specifically clarified by a constitutional bench judgment, I'm pretty sure you all are aware of, called the Balco judgment, the Bharat Aluminium judgment, where the constitutional bench made it clear that the moment a seat is designated by agreement between the parties, it is akin to an exclusive jurisdiction clause, which would then vest the court at this seat with exclusive jurisdiction for purposes of regulating arbitral proceedings arising out of the arbitration or the agreement between the parties. Now, in the past 3-4 years, there have been a series of judgments which have been pronounced by the Supreme Court, which conflict with each other. The first of them I would like to go on is the Union of India versus Hardy Exploration. Now, in this case, the parties had entered into a production sharing agreement containing an arbitration agreement. The arbitration agreement provided that the venue or of conciliation or arbitration proceedings, unless the parties otherwise agree, shall be Kuala Lumpur, and that arbitration proceedings shall be conducted in accordance with the unsettled model law of international commercial arbitration of 1985. As the disputes broke out, arbitration proceedings which were held, and they were held in Kuala Lumpur, which was in accordance with the agreement, which resulted in an award signed in Kuala Lumpur as well. The Union of India sought to challenge the award under the Indian Arbitration Act before the Delhi High Court under Section 34. No, sorry, not under 34, in the Part 2. Now, it contended that the arbitration agreement did not specify the seat of arbitration. Sorry, there was some disturbance. Am I audible? Hello?
Yes, sir, you're clearly audible.
Hello, Yashna? Hello? Sorry, Yashna, I think you're muted. I can't hear you. I'm sorry. Your voice is cracking. Hello? Am I audible, please?
Yes, sir, you're audible. Please go ahead.
Oh, cool. Sorry, there was some disturbance. I didn't recognize. Okay, sorry. Where was I? Sorry, where was I? Okay, yeah. So, it contended that the arbitration agreement did not specify the seat of arbitration and referred to the venue of arbitration only. Therefore, Kuala Lumpur was merely the venue and New Delhi was the seat of arbitration. That's what Union of India contended. Now, Hardy Exploration argued otherwise. The matter went on to the Supreme Court. The Supreme Court held that the parties had not chosen the seat of arbitration, and the arbitral tribunal had also not determined the seat of arbitration. It further held that the choice of Kuala Lumpur was just the venue of the arbitration and did not imply that Kuala Lumpur had become the seat of arbitration. According to Supreme Court then, the venue could not assume the status. Instead, a venue would only become a seat only if, and I quote, something else is added to it as a concomitant. Now, there is no exhaustive list as to what they mean by something added to it as a concomitant. So that's again a vacuum that has been left. And the Supreme Court therefore held that the Indian courts had jurisdiction to hear a challenge to the award. The decision in Hardy Exploration is, I would say, of limited assistance because, as I said, it does not clarify what is this additional concomitant that you're asking for, and it again does not delineate between seat and venue, and neither does it state factors through which one can determine it. Though this decision, the Supreme Court ultimately did not provide any clarity on the issue except the simple conclusion that venue cannot by itself be treated as a seat of the arbitration unless something extra is added. Now, what is this extra is again a vacuum and a matter of judicial interpretation. Now, shortly after that, we come to end of 2019, where a very famous case again came before the Supreme Court with the same, and this is the BGS SG. Now, this case concerned an arbitration agreement stipulating that arbitration proceedings should be held in New Delhi or Faridabad. The Supreme Court prescribed for this, in determining what is the seat in this, the Supreme Court prescribed what is known as the bright line test, which is also akin to the Shashua principle. I'm sorry if I'm not pronouncing it right, maybe my Indian accent. But the Shashua principle, which is propounded in the Roger Shashua and others, versus Mukesh Sharma, which is United Kingdom and Wales High Court judgment for determining whether a choice could be treated as the seat of arbitration. So it said as follows: if a named place is identified in the arbitration agreement as the venue of arbitration proceedings, the use of the expression arbitration proceedings, which somewhat is the same as in Section 20 Arbitration Act, that is place of proceeding, signifies that the entire arbitration proceedings, including the making of the award, is to be conducted at such a place as opposed to certain hearings. In such a case, the choice of venue is actually a choice of the seat of the arbitration. Second, in contrast, if the arbitration agreement contains language such as tribunals are to meet or have witnesses or experts heard at this place, or like the meeting will be conducted at this place, this would suggest that only the meetings are being conducted at this place. So it gives the indication toward that place not being a seat, but merely a venue. In this case, the other factors remain consistent. The venue would not be treated as a seat of the arbitration. Now, if the arbitration agreement provides that arbitration proceedings shall be held at a particular venue, then that indicates arbitration proceedings would be anchored at such venue. And therefore, the choice of venue is also choice of the seat of arbitration. The test remains subject, and contrary to what Hardy said, no other significant contrary indicia. This is in contrast to there being some additional concomitant for venue, which is held in Hardy, which I just explained earlier. Here they have said that unless there's a significant contrary indicia, they would consider the venue to be the seat of the arbitration. And in the context of international, the choice of a supranational body of to govern the arbitration, for example, make it SIAC rules, would further indicate that the chosen venue is actually the seat of the arbitration. In the context of domestic arbitration, the choice of Indian Arbitration Act would provide the indication that India is the seat of the arbitration. Now, the bright line test, as I said, contradictory to the bright line test, which is akin to the well-established principle in Shashua, that is the Shashua principle, which is followed globally and which is a common law principle, stipulated that a chosen venue could not by itself assume the status of the seat of arbitration in the absence of additional indicia. So, Soma prescribed that a chosen venue of arbitration proceedings would become the seat of arbitration in the absence of a significant contrary indicia. Now, you would be thinking, okay, on the face of it, BGS Soma gives less room for ambiguity, because at the moment there is no other contrary indicia. If imagine the proceedings are held in Delhi, there's no other thing else, and I would say Delhi is the seat of the arbitration. Whereas something, if I follow Hardy, where I'll have to look out for other additional concomitants, which also the Supreme Court has not decided, I've been left in a vacuum. And as a legal practitioner, I would be very skeptical of advising my own client about this, which would lead to a lot of problem because it adds to additional litigation costs. And the problem with BGS Soma also is that the Supreme Court has not defined here also examples as to what constitutes significant contrariation. So both the times Supreme Court has left us in a vacuum. That's the main problem. And the bigger problem than this is that both these judgments have been delivered by uh, coordinate benches. Both were delivered by 3-judge bench. Now, in BGS Soma has specifically said that hardy exploration is per incurium, since it failed to follow the Shashua principle, which was approved in the Balco judgment, which is a constitutional bench judgment. However, like I mentioned earlier, the conundrum is a 3-judge bench of BGS Soma constitutionally cannot overrule another coordinate that is hardy. So the vacuum is again here. We don't know which one is. And the same vacuum was again touched upon in 2020 in the Mankatsu Impex case in 2020, which everyone hoped would clarify this. Now, Mankatsu Impex judgment. Now, so Mankatsu versus Air Visual. In this case, Mankatsu, an Indian company, and Air Visual was a Hong Kong company. So naturally, it becomes an international commercial arbitration. The arbitration agreement provided that any dispute, controversy shall be referred to and finally resolved by arbitration administered in Hong Kong. And the place of arbitration shall be Hong Kong. The governing law in the provided that it is to be governed by the laws of India, and courts in New Delhi shall have the jurisdiction. Once the disputes arose, arbitration started, and it went and arbitration started, an award was rendered, and then went to Supreme Court. After the High Court went to Supreme Court to be challenged. Now, Mankatsu approached the Supreme Court under the Indian Arbitration Act. Sorry, I'm really sorry. I messed with that. Now, the moment the disputes broke out, the problem came to appointment of arbitrator. It provided for appointment of a sole arbitrator. Now, for this, Mankatsu approached the Supreme Court under the Indian Arbitration Act for appointment of a sole arbitrator. Now, Mankatsu argued that since Indian law was the governing law and courts at New Delhi had jurisdiction, the seat of arbitration was New Delhi, and accordingly, the Supreme Court could appoint the sole arbitrator in accordance with Section 11 of the Arbitration Act. It further argued that Hong Kong was only the venue of arbitration and not the seat, and they relied on hardy exploration. Because as I told you, it's not expressly overruled since hardy and BJs are both of the same judicial strength. On the other hand,
Hello. So you're not audible.
hello? Yeah, there seems to be some problem. Is it fine now?
Yeah.
Okay. Sorry about that. Okay. Sorry, where was I? Yeah. Okay. So Air Visual contended that since the arbitration agreement provided that the place of arbitration shall be Hong Kong and such arbitration shall be administered in Hong Kong, the seat of arbitration was Hong Kong. Accordingly, the Indian courts had no jurisdiction to appoint a sole arbitrator. And here, Air Visual relied on BGS Soma. In response, Mankatsu argued that since Hardy Exploration and BJ Soma were both judgments of coordinate benches, Soma could not have overruled Hardy and honoring curiam. And therefore, Hardy also is good law. Now, the Supreme Court, instead of decisively setting the controversy one and for all, and affirming either Hardy or Soma, and giving some breather to the legal practitioners, decided to use a different line. It altogether noted that the use of the expression place of arbitration could not decide the intention of the parties to designate that place as the seat of arbitration. And such intention had to be determined from other clauses in the agreement between the parties and their conduct. Now, till now, you would be thinking, okay, so Supreme Court at this time is leaning towards hardy exploration. But wait, Supreme Court then went on to hold that the choice of Hong Kong as the place of arbitration itself did not lead to the conclusion that the parties had chosen Hong Kong as a seat of arbitration. However, because the parties had also agreed that such arbitration was to be administered in Hong Kong, Supreme Court ultimately held that the parties had chosen Hong Kong to be the seat of the arbitration. Now, in this, neither did they affirm Hardy, neither did they affirm Soma. They, like, I would say, stood on both the planks and took a third way and just gave their judgment and washed off their hands. Personally speaking, I would say BG's Soma is something which is to be followed, or like something which I would say leaves less ambiguity. Because as I earlier said, sometimes the arbitration clauses are not properly drafted, and this leads to a lot of uncertainty and skepticism. And now, if I say that the arbitration has to be conducted in Delhi and just leave it out there, like all these commercial dispute, a lot of commercial disputes clauses and all, which are not properly drafted by professionals, have such clauses. Now, in this thing, as a legal practitioner, and also you got to see that the law is here to help the citizens or the residents. Is here to help, not create an ambiguity. Now, as a layman, if you see, I would say, yeah, okay, Delhi has everything, and Delhi is the seat. But now, if you put on the legal things, it undermines the main objective of arbitration, because by leaving such ambiguity, you're giving rise to more and more litigation, which vis-a-vis gives way to more and more litigation costs. Time duration for disposal of the cases increases, and the ultimate objective of the arbitration, which is speedy private disposal of litigation, is lost. Everything is lost out here, because a point of jurisdiction, and at least for the time I have practiced, this is something which really frustrates a client as well, because it's not something which is his fault or her fault. And they would want their disputes to be resolved. And this is something which they even had not contemplated. It's neither the respondent's fault or the petitioner's fault. It is something which is a legal concomitant, which results in innumerable litigations, and the time for disposal of such cases is easily 1 to 2 years, which has again, like, one of the main reason why it has pushed India back in the index of arbitration disputes back in the line a lot. Now, the last but not the least, the parties would also be asking, why is that they're so keen on determining seat? Why is that they just don't agree between themselves as to the jurisdiction of the court and save legal costs, which many people have heard saying this. The main reason for this, I would say, at least in my personal experience, is judicial intervention. Now, I'm not sure. I'm sure all of you have heard the recent Supreme Court judgment of PASL Wind Solution Private Limited versus GE Power Conversion India Private Limited, where the Supreme Court has finally held that two Indian parties can choose a foreign seat of arbitration. Now, why is that parties are choosing this foreign seat of arbitration? Why would you want to increase the litigation cost by making something like Paris, Singapore, or London as your seat, and rather just have it somewhere in Bombay, Delhi, Calcutta, the thing, and save costs? Why would you do that? Well, the main thing comes here is because of our Arbitration Act. Now, as you all are aware, the Part 1 of the Arbitration Act applies to arbitrations which take place in India. And the arbitration which takes place in India have unfortunately extrajudicial interference, which is patent illegality appearing on the face of it. So private parties have chosen arbitration so that there is minimal judicial interference and speedy disposal. The more the judicial interference is there, the more legal costs are going to increase, the more time for resolution of the disposal of the dispute is going to increase, and the uncertainty between in the business world during the pendency of the thing of the dispute is going to cause problems. Now, this patent illegality appearing on the face of it is right now the main reason why people, instead of choosing domestic, are going international, and why India is losing out on business. And it's the main reason why we are getting pushed back more in the index of India as being a favorable country for arbitrations. So, as my friends, like I said on the starting of the thing, seat is a very important concept, which, if you just read academically, would say that, oh, this is the jurisdiction and this courts have it, but it leads to a lot of problem because because the problems which that come with it are have serious business repercussions. I hope my webinar till now has given you some insight into what a seat is, its importance, and how one can distinguish the difference between a seat and a venue, even though the Supreme Court itself has not been too clear with it. And sure, it has to be referred to a constitutional bench to finally set the line straight. Uh, but for you all, I have a question. I have a simple problem questionnaire, which I would love for you all to answer, to read and see that what views can you come up with about what is the seat in that scenario, and we all can have a healthy discussion in light of the presentation, in light of the webinar that I have just delivered to you all. Yashna, can you please put up the problem question?
Yes, sir.
Sorry, is it my stuck or have you put it?
No, no, sir. Just a minute.
For those who have joined from their phone and are not able to read this properly, I would help you out and read it out aloud for you guys. Now, this is a scenario which I've taken out. Now, imagine a clause of an arbitration agreement reads as follows: the arbitration is subject to English law, and the seat of the arbitration shall be Glasgow, Scotland. Any such reference to arbitration shall be deemed to be a reference to arbitration within the meaning of the Arbitration Act 1996 of United Kingdom or any statutory reenactment. Now, another clause says the contract shall be governed by and construed in accordance with the laws of England and Wales. And subject to clause 20.2, the parties agree that the courts of England and Wales have exclusive jurisdiction to settle any dispute arising out of or in connection with the contract. Employer referred, now this is there. Now here the dispute was referred to arbitration, and the problem came as to what is the seat. Is seat the Scotland, which is specifically stated, or is it England? I would love your views on this, and we can probably have a healthy discussion. You can either put your thing on the chat box or anyone can raise a hand or probably just get in. A lot of deliberations, I reckon. Give it a minute. Think about it. In light of Hardy, Soma, Mankatsu, Balko, something which is specifically stated to be the seat, and whereas there's another clause which says that it has to be constituted in accordance to England and Wales. What is the anomaly out here? What is the seat? Is the earlier clause 20.2 a mere verbiage? Or is clause 1.4.1 a mere verbiage? This is something which we all as legal practitioners will come across sometime or the other. Well, okay. No, no volunteers out here. Okay, fine. I can understand. It's a very tough one to get through, and this is the same thing. Which this is actually a case scenario from a famous case of bride or downwind farm case versus the Alfred McElfeen Business Services case of the United Kingdom. This is one of the landmark judgments of the United Kingdom, and where this was held, and I would feel that it was rightly held, that the phrase has the effect depends on the party's intentions to ascertain from the whole of their agreement. Now, particular importance is attached to clause 1.4.1, as you see. Now, unless this is pure verbiage, it gives English courts jurisdiction which relates to the control of the arbitration. While reference to arbitration, which appears in clause 20.2 subsection C, is not a legal term of art. The deeming phrase in clause 20, in this clause 20, when the parties intended Arbitration Act 1996 to apply to their arbitration. Accordingly, in the contract, the word seat in clause 20 is simply where the hearings in the arbitration would take place in Glasgow and was not designated the seat for the purpose of Arbitration Act. This, my friend, is an example I would like to give, that even though you have just stated it to be a seat, it might not come down well with the courts. They might decide otherwise. So you got to be very careful in discerning when you say that just because you have stated that this is the seat, are the courts going to take it well down, saying that this is the seat of the arbitration and done and dusted? The judicial courts have a very time their own thing, but as you get into the profession and you decipher and go deeper into it, you will realize that this is actually the right approach. Just because they said that this is the seat does not mean the contrary indicia, which is there, which is sort of like a mixture of, I would say, Hardy and BGS, has come to the conclusion that that is just because it is a seat, it is not a seat, it is a venue. The contrary indicia of Arbitration Act 1996 applying makes it clear that England is the seat of the arbitration. I hope this small webinar gave you a chance of some insight into the complexities of arbitration, what we as practitioners of arbitration law go through on a day-to-day basis, where such a small point, which is at the beginning of a dispute, where the substantive dispute has not even been raised yet, can create so many problems. this is something which, if you're in the transaction world, you have to be very careful about making it clear. Non-verbiage might help, but again, it might sometimes not go down well with the courts. And this is something which the clients specifically wouldn't like because it leads to unnecessary litigation costs. Any questions I'm happy to address?
So thank you so much for such a great session. I think this is the time for question and answers rounds. Guys, if you have any questions or any discussions or any views or points you want to put forward, please, this is your time. So we'll be more than happy to address it. So please, if there are any issues or any queries, please ask them. You can either put it up on chat box or just unmute yourself. We'll unmute yourself. You can just write in the chat box. So I think the topic is pretty clear to all the participants that there's not even an iota of doubt left in their mind. So
Well, that's great. I hope I hope the Supreme Court also hears this and clarifies my doubts, because I have many. Perfect then. Hope people already learn something from this and get to take away something. And people who have not yet joined the profession, I hope I have given a birth to into arbitration, and they really do fall keen into practicing this area of law. And thank you, Yashna, for having me. Thank you, participants, for coming here, joining this webinar, and giving me an opportunity to address you and spread over my knowledge. Because, like how in Munafha it says that "Gyan baatne se badhta hai." I'm a really firm believer of that. And yeah, thank you, everyone. It was great having you all here. Thank you, Vidhi Parivartan, for having me. This was a great experience for me as well, considering even I'm at the nascent stage of my profession. And yeah, thanks a lot.
thank you, sir. Thank you so much. It was a really informative and knowledgeable session. I thank all the participants as well for being a patient listener. We appreciate your time and patience, and we will make sure that we keep serving you with all such webinars in future as well. Thank you. Thank you so much.
Thank you.